We got sentencing in two matters. People v. Michael Martin, file 23-6767 FH and 24-6880 FH. Counsel, you want to state your appearances beginning with people, please?
Melissa Goodrich, Wayne County Prosecutor.
Jennifer France, P60725.
And I discussed with counsel at the bench briefly a couple issues. Number one, we've got some pending show causes that were lingering out there. I guess we're here for sentencing on two felony matters with recommendations that sort of eclipse any contempt matter. So at this point, I'll dismiss the pending contempt citations. And also, this was a case where Mr. Martin had been on parole. While these cases are pending, the Department of Corrections has discharged him from parole. And so therefore, in the pre-sentence report in file 6767, Agent Young, it looks like we need to give him additional credit from the time that he was discharged, that being 71 days. And I discussed that with counsel, and Ms. France, do you agree with that calculation?
I do, Your Honor. Thank you.
Ms. Goodrich?
Yes, Your Honor.
Okay. All right. So, Ms. Martin, have you had a chance to review the pre-sentence report and recommendations in both files with your client?
I have
Do you have any additions or corrections to the factual information in either of those reports?
nothing to the factual information on either report.
And in file 6767, you did file two scoring challenges. Why don't we go ahead and take those? You want to argue your OB-15 first?
I only had OB-19, you know. OB-15, I believe, was the people were requesting that to be scored.
Well, no, OB-15 was scored at 5 points. And you were arguing that it should be scored at 0.
Correct, Your Honor. That is trafficking and forgive me. Brain was stuck on the last case. On this particular case, as the court is very much aware, Mr. Martin was the passenger in the vehicle. The driver of the vehicle was the one throwing out items, allegedly drugs out there. He was also the one in control of the vehicle. The only way Mr. Martin could have not been involved was to jump out and risk his own life, which is not ever wise either. They were in a chase, it sounds like, and the other driver of this car prevented Mr. Martin from doing anything safely. So to score him for OB-19 for the threat to administration of justice is inappropriate because he was unfortunately an unwilling participant at that point because he's no longer the driver of the vehicle and the vehicle is moving at such a speed he cannot get away. Also, with the amount of drugs to indicate trafficking, that would also more go towards the driver of the vehicle as well, because it was the driver throwing everything out the window and commanding everything at that point. So I would ask for 15 and 19 before that 0. Thank you.
Okay, thank you. Ms. Goodrich, people's position?
Yes, Your Honor. One of the things not required is that he actually be charged with the fleeing or living. I think he was part of the that post-offense conduct by being part of the vehicle and the drug activity, and I think it was part of the score.
Okay. All right. As to OB-15, it was scored at 5 points for the defense involved the delivery or possession with intent to deliver controlled substance or possession of controlled substance having a value or under circumstances as to indicate trafficking. Trafficking is defined as the sale or delivery of controlled substances on a continuing basis to one or more other individuals for further distribution. So the Michigan Supreme Court has interpreted OB-15 to say that we do get to score it anytime there's a delivery or possession with intent to deliver charge, but for a possession, there must be evidence of trafficking, which under that definition requires sort of a two-step distribution. Trafficking is distributing, selling or delivering controlled substance on a continuing basis to somebody for the purpose of further distribution to yet another person. And because the sentencing offense is a possession, therefore that statutory definition of trafficking would have to be satisfied. I don't see any evidence of that. So OB 15, I would sustain the challenge and score OB 15 at 0 points. As to OB 19, during the chase of the vehicle, the pre-sentence report indicated that there were items being thrown out of the passenger side of the vehicle. I find that to be a sufficient preponderance of the evidence that Mr. Martin was indeed participating in the behavior of trying to destroy evidence before their apprehension, and that would be post-offense conduct is scorable under OB 19. So I would find that OB 19 is properly scored at 10 points for interfering with the administration of justice. So the total OB is 10 points. I believe that still retains it at OB level 2. Guidelines remain at 19 to 47 months. All right, Ms. France, anything you want to say on behalf of your client in both matters?
Thank you, Your Honor. As for my allocution for both cases, my recommendation is still going to be the same in both cases, Your Honor. I did explain the hoping this has made it click for Mikey having the baby inheriting his heart issues. I'm hoping he's had a long history of substance abuse. PSI history shows it. This is a kid that he struggled. There's just no better way. And he's got one or two choices to make right here and now, and that is put our big boy pants on, take care of our child, or do life on the installment plan in prison. Unfortunately, most courts would probably just say, well, too bad, so sad, life on the installment plan for you. But he's never had the opportunity of being in that father role and having that awestruck moment where your life completely changes forever. That happened to him while he was in the jail and heard the baby's heartbeat, and then find out the baby has inherited his genetic heart failure. I can't imagine how that felt to him. And then to be locked in that jail, not able to even hug his partner or console her. That, I think, has been the clicking moment. They always say someone needs to hit their rock bottom. I believe this is where Michael is at. These sentencing guidelines are not binding. We've all learned that lesson from Lockridge. I would ask the court to consider 3 years probation, order him to serve a period of 9 months, and order 2 years over his head. He screws up one time, he's going to the Michigan Department of Corrections. Some people would say we're giving him the rope. Let's hope he doesn't hang himself with it. But this time he comes before the court with a very different reason to get his act together. It's always easy in your 20s and you say you're going to change, you're going to change, you're going to change. We all did it. But when you now become a parent, that changes your whole world. And I think at this time, we have met that. I would ask that these sentences be concurrent. We are dealing with, unfortunately, methamphetamine in the first case, but Adderall in the second case. And I don't mean to make it sound like Adderall isn't important. It is important. It is a controlled substance. But if I have to pick the two, I'd rather someone was selling an Adderall pill versus a methamphetamine pill. And not to make light of Adderall at all. I mean, you used to be able to buy it over the counter to get through exams. Now it's a controlled substance. I would ask the court to take all of that into consideration in both memorandums and grant our request for a unique sentence for a unique situation. Thank you.
Thank you, Ms. France. Mr. Martin, it's not required that you would say anything today, but it is allowed. Is there anything you want to tell me or no?
Yes, sir. Like I said in that letter, I stand before you today, a young man ready to accept the consequences for his actions, and I accept full responsibility for what I've done. I'm really ready to just move forward past all this and start this next chapter of my life and be a better partner to my significant other and a positive father figure for my child once he comes. Thank you.
Thank you. Mr. Rich, people's recommendation.
Thank you, Your Honor. The defendant is 25 years old. At that young age, he already has 5 felonies and 4 misdemeanors, which is significant for such a young age. He's here to be sentenced on the possession and delivery of pleas. He has made choices after being offered previous services of probation and incarceration, and here we are today, the second one being committed while he's on bond for the first. I know that sometimes people think, oh, well, having a child changes things, but there's probate courtrooms full of cases where people still continue to make bad choices despite having children. Oftentimes you have to make that decision first for yourself before you can help others or be anything for others. And I think that by Mr. Martin's actions and choices, that the court should follow the recommendation, and I believe that it should be ordered consecutively. Thank you.
Thank you, Mr. Martin. If you please stand for the fourth sentence. Mr. Martin, you know, your lawyer's done a great job for you throughout this case, and you haven't really made your job all that easy. While you've got a pending case for possession with intent to deliver methamphetamine, and should get you an outcome down to a possession, you're still out there while you're on bond for a serious felony, and you're out there selling drugs and saying gets a controlled buy-in to you while you're on bond in a drug case. That's just a spectacularly terrible decision. When I kind of back up and look at this case, you were, your last sentence was 3 years in prison. So you're on parole from a sentence where you went to prison for 3 years. While on parole, you're involved with Mr. Sayers with you know, enough methamphetamine that it was intent to deliver for sure. And then, you know, the degree to which you're participating in the chase may be unclear, but you're definitely not a kidnapping victim here. You're tossing the drugs out the window. You know, you're running wild out there while you're on parole. And then while you're on bond for that case, you end up, I don't know, there was a parole detainer, and then I think when they discharged it, well, yeah, so then they finally discharge you from parole, which Lord knows why the Department of Corrections would discharge you from parole when you committed a felony crime while on parole. I don't know why they don't wait around and, you know, maybe return you to prison, but I think they like to say that their recidivism numbers are so low, they didn't return you to prison. You had a successful parole. Well, you had anything but a successful parole because you're out there involved in methamphetamine while you're on parole. So the parole detainer goes away and you go out in the community and you just continue to run wild and you're selling drugs and you're selling it to a CI. That's just quite a series of events, Mr. Martin. When you were on parole for a 3-year sentence and then you're involved with methamphetamine drug activity that did involve distribution of drugs, not enough to show the 2 levels for the possession. But that's a relevant factor. And you didn't do well on bond. I dismissed a couple of show causes today, but I mean, you had some positive tests for methamphetamine and for alcohol. And then you're out there committing more crimes, deliveries while you're on bond. It's unlikely that the sentence goes less than what you had last time, right? When you get 3 years and then you behave in the way you did, usually we're going to ratchet this up a bit. So this is, I mean, there's obviously good reasons to even go above those advisory guidelines. I think that for sure, I'm very sure that upper end of that advisory guideline range is a definitely proportionate sentence given the circumstances. So in file 6767, I am going to commit you to the Michigan Department of Corrections for not less than 47 months, nor more than 15 years, exercising my discretion under the habitual offender statute to increase the statutory maximum. I'm going to give you credit for 71 days previously served after the parole detainer evaporated when they discharged you. There's also state costs of $68 and $130 in a crime victims assessment and $200 restitution. In file 6880, this is the delivery while you were on bond for the methamphetamine case. There's restitution of $70, state cost of $68, crime victims assessment of $130. And I will commit you to the Michigan Department of Corrections. Again, I think a term on the upper end of the advisory guidelines is certainly proportional for the fact that you're out there selling drugs while you're on bond for a drug case. So I'll commit you to the Michigan Department of Corrections for not less than 23 months, nor more than 7 years. It is discretionary consecutive, and Michigan does prefer concurrent sentencing, has a strong preference for that. But while somebody's on parole, involved in drugs, and then while they're on bond for that, they're selling drugs.
The judge doesn't soften his words. He tells the defendant that the lawyer did his best, but the defendant destroyed his own case. He was already out on bond for a serious crime and still chose to sell drugs. The judge makes it clear this wasn't just illegal. It was a terrible.
I'm not sure there's a whole lot more cases that call out for consecutive sentencing more than that, just continuing to do that while you're involved in the system. So I'm going to exercise my discretion and run those consecutive, so you get 0 days credit on the second case. Mr. Martin, you can appeal your conviction or my sentences or both by filing an application with the Court of Appeals. If you want a lawyer, I'll give you one, but you have to ask me within 42 days. So we're going to hand you some paperwork explaining the appeal process, ask you to initial one copy for us, and the other one is for you to fill out if you want to take an appeal. Good luck to you, Mr. Martin.
When court resumes, the judge begins sentencing. It quickly becomes clear this isn't about one case. There are 2 separate felony cases. That's when everything clicks. This isn't an accident or bad luck. It's a repeated pattern of bad decisions. And the defendant didn't learn anything the first time.